The Committee on House Administration will come to order. We acknowledge that we have a quorum present, and I want to wish everyone a good afternoon. As we begin, I want to note we're holding this hearing in compliance with the regulations for remote committee proceedings pursuant to House Resolution 8. We ask committee members and witnesses to keep their microphones muted when not speaking, to limit background noise, and people will need to unmute themselves when seeking recognition or when recognized for questions and answers. Members and witnesses, please keep your cameras on at all times. The rules require that. Even if you need to leave the meeting, please do not turn your camera off. And also, we're noting that the rules do not permit members to participate in 2 remote hearings at the same time. At this time, I ask unanimous consent that all members have 5 legislative days in which to revise and extend their remarks and have any written statements be made part of the record, and without objection, that is ordered. I also ask unanimous consent that the chair be authorized to declare a recess of the committee at any point without objection. That is also ordered. Today marks the first hearing of the office on the Office of Congressional Workplace Rights since the Congressional Accountability Reform Act was enacted on December 21st, my birthday, 2018. The reforms granted by this change to the Congressional Accountability Act, commonly referred to as the CAA, represented the first substantial change to Congress's workplace laws since the law's inception. The most extensive changes came to the administrative dispute resolution process, providing employees with a more streamlined and less time-intensive process, eliminating mandatory mediation as a prerequisite to filing a CAA-related claim, creation of an online intake system, and holding members accountable for settlements and awards in which they are personally involved and that deal with harassment are just some of the elements of the Reform Act. While these introductory measures are laudable, it's unfortunate that critical pieces, such as members of Congress being responsible for repaying money back to the Treasury where they are personally responsible for discrimination, was left out because of the Senate's position. Despite this glaring omission, House Democrats were able to include a provision in the House Rules package to hold House members responsible for Treasury repayments in instances where members are personally responsible for discrimination. The House has led the way on workplace rights by going further than the CAA Reform Act to establish a variety of measures to strengthen our commitment to providing a harassment and discrimination-free culture and workplace. Some of these measures include providing a free and confidential legal resource for covered House employees who have questions, concerns, or claims, or legal representation dealing with the CAA, mandating the posting of workplace rights notices by employing offices, and instituting mandatory anti-harassment and anti-discrimination training. While these steps marked a good start in our efforts to ensure employees of the House have greater protections, we have to remain vigilant to ways in which we can further improve and strengthen the congressional workplace culture to provide a safer and more inclusive environment for everyone. After 24 months of having the CAA reforms implemented, the Office of Congressional Work Rights has some basis to provide the committee with an update on how well the reforms seem to be performing and suggestions for ways in which Congress and the House can strengthen employee protections. And I look forward to hearing their testimony on this subject this afternoon. And it's worth noting that these reforms, although the focus is often on the members of Congress themselves, there are many, many people who work on Capitol Hill, whether they're in the shop or whether they're an electrician or in tech work, that do not directly work for a member of Congress. And all of those people also need to be free of harassment or bias in their workplace. So at this point, I would like to recognize our ranking member, Mr. Davis for any opening statement that he may wish to offer.
Well, thank you, Madam Chair, and thanks to all of our colleagues and our witnesses today. In 2018, Democrats and Republicans in the House and the Senate worked to pass the first overhaul of the Congressional Accountability Act since, as Chair Lofgren spoke about, since it was passed in 1995. It passed the House unanimously. The reforms included in the bill were based on the findings of a comprehensive review of the laws, procedures, and resources related to sexual harassment within the House. Our overall goal with these reforms was to professionalize the House by bringing more transparency to the process, ensuring bad actors are held accountable, and creating stronger protections for employees. Now, almost 3 years later, we have a responsibility to determine whether these reforms are working, if they're helping accomplish our goal of professionalizing the House. As a side note, I believe we need to be holding more oversight hearings like this one, especially since COVID has changed how many of the House offices operate. One area that needs to be assessed is the workplace rights training that's mandated by the Congressional Accountability Act. Under the Congressional Accountability Act, in-person training for members, staff, and interns is required each year. However, COVID quickly forced the workplace rights training to go completely virtual over the last 2 years. As a former district staffer for 16 years, it's critical for us in Washington to consider the practicality of programs that are passed out in DC, where staff are all in the same place. And let's check with the impact on district staff, where they can sometimes be in multiple different offices, hundreds of miles apart, depending on the district. For example, allowing this training to be conducted virtually has made it much easier for the interns and staff in my district in the state of Illinois, which covers 14 counties, to receive training in a timely and efficient manner. Before, when training was in person, the district staff would sometimes have to spend an entire day just to travel to and from the training because it might be offered only once at a single location. This left them unable to help constituents during that time. And additionally, it's an added cost to taxpayers when they have to pay someone from Franklin Covey to be sent to all 435 districts across the country. I look forward to discussing with our witnesses the effectiveness of this virtual training and the potential for OCWR to take on the implementation of this training themselves rather than contracting it out, and the impact this may have on the program and whether it can save taxpayer dollars. Lastly, I want to mention the search for a new executive director. Congratulations to the current ED, Susan Grunman, on her new position, and I want to thank her for her service. It's important for us to understand the timeline and process for choosing her replacement, and I would very much like to be consulted on any potential replacements. OCWR works closely with member and committee offices, so we want to make sure that it is responsive and helpful for all staff and members. With that, I look forward to hearing from our witnesses, and I yield back, Madam Chair.
Thank you, Mr. Davis. Other members' statements will be put in the record. And now I'd like to introduce our panel of witnesses. Our first witness is Theresa M. James, who was named the office's Deputy Executive Director for the House of Representatives in June of 2018. She is responsible for the Office of Congressional Workplace Rights, Legislative and Public Affairs, and Education programs on workplace rights, safety, and health, and public accessibility mandated by the Congressional Accountability Act. Ms. James, who came to the office in 1999, previously served as director of the Administrative Dispute Resolution Program and was primarily responsible for the processing of all informal and formal claims concerning workplace rights afforded to legislative branch employees under the CAA. Our second witness is the chair of the OCWR Board of Directors, Barbara Childs Wallace. Ms. Wallace was appointed in 1999 by the joint leadership of the United States Congress to serve on the Board of Directors of the Office of Compliance, which was the predecessor to the Office of Congressional Workplace Rights. She assumed the duties as its chair in April of 2017. In her private capacity, she has over 30 years of experience in employment and labor law. And our third and final witness is Barbara Kamens. Ms. Kamens was appointed in 2000 by the joint leadership of the United States Congress to serve on the Board of Directors of the Office of Compliance and previously served as its chair. In her private capacity, she represents labor unions in all aspects of labor management relations and employment law. and represents and advises on all legal aspects of employee benefit plans. She has extensive litigation experience before federal courts, administrative agencies, and arbitrators. We look forward to hearing your insights as to how implementation of the reforms are working, any notable changes versus pre versus post reform, any challenges that the Office of Congressional Workplace Rights may have encountered in the reforms implementation, and if OCWR has any recommendations for strengthening the reforms. I'll remind the witnesses that their entire written statement will be made part of the record, and that the record will remain open for at least 5 days to receive additional material that is submitted. We have a timer on the screen, so we ask when your time is up that you summarize as much as possible so we can go to the next witness. And first, I would like to call on you, Ms. James, for your testimony.
Thank you. Chairperson Lofgren and Ranking Member Davis and members of the committee, on behalf of the staff of the Office of Congressional Workplace Rights, thank you for the opportunity to discuss the mission of our office, the work that we do to advance workplace rights, safety, health, and accessibility in the legislative branch, and the lessons that we have learned since the implementation of the CAA Reform Act. I first came to work for the office in 1999, and since that time, I have served as director of the office's administrative dispute resolution process, and now as deputy executive director, where my focus is on education and outreach to the congressional community. During my tenure, it has been a privilege to work with stakeholders and colleagues who have dedicated their careers to making the legislative branch a model workplace that is respectful, safe, healthy, and accessible, with equal employment opportunity and treatment for all. I understand that the purpose of this oversight hearing is to gauge the effectiveness of the CAA Reform Act over the last 2.5 years and to discuss our lessons learned. And part of that process involves looking at data and case processing statistics and attempting to identify trends. It can be frustrating to try to determine whether an increase or a decrease in a number is statistically significant or what caused it. And it's not always possible to determine whether the change is an indicator of progress or whether it's attributable to an external factor such as the COVID pandemic. But we want to draw unambiguous conclusions from ambiguous statistics, and we understandably want measurable indicators of success. And sometimes, through that process, we are able to sift through the numbers and glean valuable information to assist us in carrying out our mission. But I would also like to offer the members of this committee my personal experience as a veteran of this office for more than 20 years. I worked for this office when it was known as the Office of Compliance, and virtually nobody on the Hill had any idea who we were, what we did, and how to contact us. I worked in this office developing materials on unlawful discrimination and harassment for training that nobody was required to take. And I worked in this office designing and printing posters on employee rights that we were required by statute to produce, but nobody was required to post. But now I have also worked for more than 2 years in an office renamed as the Office of Congressional Workplace Rights. The blank stares and shrugs I got when I mentioned my office have now been replaced with nods of recognition and questions concerning employee rights and protections. And I have now worked in an office that is at the forefront of developing materials for mandatory training on anti-discrimination and anti-harassment protections for congressional employees and on many other important protections embodied in the CAA. And I've now walked through the halls and tunnels of this Capitol Hill campus where our workplace rights posters clearly tell employees, as well as unpaid interns and fellows, who we are, what their rights are, and how to get help. So whereas in the past, a statistic showing a drop in number of claims was likely attributable, at least in part, to the fact that victims of harassment, discrimination, and other unlawful conduct had no idea where to turn for assistance. After the Reform Act, it is much more likely that a similar number is an indication that the workplace climate on the Hill is truly improving, that employees and employing offices are aware of and understand their rights and obligations, that education and outreach is translating to change in behavior, and that the Reform Act's amendments to the CAA are succeeding. I greatly appreciate the steadfast support of this committee as we work together to make the legislative branch a model workplace. We have much work to do, and we must remain vigilant to ensure that recent reforms are permanent reforms. Thank you, and I welcome any questions that you may have.
Thank you very much. We'll turn now to Ms. Wallace. Ms. Wallace, we'd love to hear from you for about 5 minutes. But you need to unmute.
There. Can you hear me now?
Yes, we can.
Okay, sorry. Thank you, Chairperson Lofgren and Ranking Member Davis and members of the committee. I'm honored to have the opportunity to testify regarding the work of our office. This is my second opportunity to testify before this committee and assist it in its important work. The first was in 2017, at a time when workplace harassment on the Hill and elsewhere was a daily part of the national dialogue. Although much has changed since then, our office's steadfast commitment to advancing workplace rights, safety, health, and accessibility in the legislative branch has not. It's an honor to be here today to speak not only on behalf of our wonderful and committed staff, but also on behalf of the Board of Directors, which I chair. The other members of the board include Susan Robfogel of New York, Alan Friedman of California, Roberta Holtzworth of Illinois, and Barbara Kamens of Washington, D.C., who's here to testify also today. We were appointed to these part-time positions by the majority and minority leaders of both houses of Congress. All 5 of us have decades of experience representing clients in the private and public sectors on labor and employment issues. The CAA requires that we be appointed without political affiliation, and the board works diligently and in a nonpartisan manner to ensure that the principles embodied in the CAA and the CAA Reform Act are carried out. Although our office has a staff of only 30 employees, we have a very broad mandate. We're responsible for enforcing the federal workplace and accessibility laws that cover more than 30,000 employees in the legislative branch. And we perform the functions of multiple agencies, including the EEOC, the Department of Labor, the Occupational Safety and Health Administration, and the Federal Labor Relations Authority. This year marks the 25th anniversary of the passage of the CAA, which designates several primary responsibilities for our office, although there are many others. First, we inspect the Capitol grounds to ensure that they are free from occupational safety and health hazards and are accessible for people with disabilities. Second, and especially pertinent to the subject of this hearing, we provide an administrative dispute resolution program for employees to assert their rights and protections under the CAA. Third, we draft and adopt regulations concerning the statutes made applicable under the CAA. Fourth, this office maintains a robust and comprehensive education and training program about rights, responsibilities, and protections under the Act. And Theresa James, who just spoke, is the person in charge of this and is doing a marvelous job. And finally, the board reports to each Congress on recommendations for changes to the laws made applicable to the legislative branch. And also, this also marks the second full year implementing the provisions of the Reform Act, which we'll be talking about, which made many important changes to the CAA, including substantially modifying the ADR process, requiring members and employing offices to reimburse the Treasury for certain awards and settlement payments, appointing confidential advisors to provide information to employees about their rights, renaming our office, extending certain CAA protections to unpaid staff, and developing and implementing the means to educate and train employees who work outside of the Washington, D.C. area, which I believe Ranking Member Davis spoke to. I stated in the OCWR's annual report for 2019 that the enactment of the Reform Act meant that 2019 would be the most challenging year for our office since it opened its doors in 1996, and it was until 2020 and 2021. None of us could have predicted then that much of our experience under the Reform Act would be while operating remotely as a result of the COVID-19 pandemic. Despite that fact, we still have been able to carry out each of our ongoing missions remotely. I'm pleased to report that the OCWR's doors have now been reopened during normal business hours, and so we are now staffed to accommodate both in-person and virtual business. So although 2020 and 2021 are certainly contenders with 2019 for the most challenging year for our office, I'm convinced that the OCWR is now better situated than ever to carry out our critical mission on Capitol Hill. I thank the members of this committee and for their unwavering support of our critical work, and I look forward to answering your questions.
Thank you very, very much. And finally, we will hear from Ms. Kamens. We welcome your testimony for about 5 minutes.
Chairperson Lofgren, Ranking Member Davis, and members of the committee. On behalf of the board and the staff of the Office of Congressional Workplace Rights, I thank you for the opportunity to appear before you today. As a member and a past chair of the board, it's been a privilege to work with this committee and with other stakeholders who share our commitment to make the legislative branch a model workplace. One of our board's primary responsibilities is to report to each Congress on our recommendations for change to federal workplace laws that may apply or should apply to the legislative branch. We refer to these as our Section 102B recommendations. Our board appreciates that the Reform Act incorporated many of our past recommendations for change that we think are essential to transforming the workplace climate on Capitol Hill. The Reform Act incorporated our longstanding recommendation that employing offices be required to post notices of workplace rights. For years, our office was required to produce the notices, but as Ms. James mentioned, there was no requirement that the notice be posted. And our board had long been concerned that victims of harassment and other unlawful conduct might not take action simply because they were unaware of their workplace rights. The now mandatory notices clearly notify employees of their rights and responsibilities under the Act, and they serve as a visible commitment on the part of Congress to the workplace protections that are embodied in the CAA. The Reform Act also incorporated our recommendation that Congress change our name. For more than 20 years, we were the Office of Compliance, a name that offered no indication of what we did. We are now the Office of Congressional Workplace Rights, a name that reflects our mission, informs employees of what we do, and makes it easier to find us should someone need our assistance. Our board had recommended that the anti-discrimination and anti-harassment protections of the Act apply to all staff, including interns and fellows, who are among the most vulnerable members of the Capitol Hill workforce. The Reform Act now extends these protections to unpaid staff. And finally, the board had consistently recommended mandatory training on issues of discrimination and harassment. The House and the Senate have now adopted resolutions that require all members and staff to complete an anti-harassment and anti-discrimination training program, and the Reform Act extends these training mandates to the congressional workforce at large. In short, we think that Congress got the Reform Act right, and we commend them for it. Our board has an additional 102B recommendation for change that I would be pleased to discuss further in this hearing, and that is to make mediation available at the request of a claimant, regardless of whether the employing office specifically agrees to the process. We believe that mediation is a highly effective tool in resolving workplace disputes, and that such a change would further strengthen the statutory reforms. Training and education remain among our most critical statutory responsibilities, and the Reform Act presented our office with a clear opportunity to expand the scope of education and outreach, and our office fully met that challenge. We have built out an ambitious, innovative training program that goes beyond the letter of the law to address a wider array of issues, including best practices that ensure a safe and respectful workplace. We offer training directed to the entire congressional workforce, from members of Congress and senior staff to entry-level employees and interns, and we will tailor our training to meet the unique needs of any employing office. We have added to our team of training specialists, and we have harnessed technology to deliver education through our website, in person, and through video conferencing that makes our training fully accessible to the entire legislative workforce, including in state and district offices. I am so very proud of our education program and the fact that it is recognized as such an expert and trusted resource on Capitol Hill. Education remains essential to reform and to our office's strategic vision of a respectful, safe, and healthy congressional workplace. I thank this committee for its unwavering support and for the privilege of your time, and I look forward to answering your questions. Thank you.
Thank you very much, Ms. Kamens, and to all three of our witnesses. Now is the time when members of the committee can question the witnesses for 5 minutes. I'll turn first to our ranking member, Mr. Davis, for questions that he may have.
Thank you again, Madam Chair. Really appreciated hearing the witnesses' testimony today. And my first question is going to be for Ms. James. As you know, on the 116th Congress, this committee did pass the CAA Reform Act to ensure a safer and more professional work environment for all who serve within the legislative branch. And we remain committed to bringing more transparency and accountability to the U.S. House. Based on your many years of experience at OCWR, what improvements have you seen since the implementation of the Act in 2019?
James being fine.
I think you're muted, Ms. James.
I think I'm off now. Am I okay?
Yeah,
Yep.
we can
My
hear you.
apologies. Overall, as you know, since the reforms have taken place, we have seen a small decrease in the number of claims filed. We have seen employees still contact our office for advice and information about what their rights are. We also are looking at what the implications are for the office, and we've looked at things like perhaps it's because there's mandatory training, and now employees know what their rights and protections are. It could be because people have been working in the remote work environment since COVID started. But we have seen also that mediation is down slightly. And so we think that mediation is an opportunity, as Ms. Kamens said, for the parties to meet together, talk about what their dispute is, and see if there's a way to resolve it through a mutual agreement. But we are seeing that, mandated training, the posting of notices and other things seem to have really informed staff throughout the legislative branch and remind them of what their responsibilities are.
Well, let me jump in here real quick, Ms. James. You mentioned the mediation that your board members mentioned in opening testimony also. Are there any other changes that you still think need to be made to the CAA?
Boy, that's a big question. I mean, there's a lot of issues when it comes to substantive matters that, as people are looking at what the provisions are. I think we've made some recommendations as to other areas that we might want to consider being applied to the Congressional Accountability Act. We have a list of new provisions, but otherwise I think that what we have with the process is really working out well for both staff and employees.
Okay. Do you believe that congressional staffers are properly informed of the work that OCWR does?
I do think so. I hope so. We put out newsletters, we put out posters, they're mandatory training, there's mandatory posting of the posters. we're doing everything that we can to get the word out that we are here, that we are a available resource for staff, for them to understand what their protections are and the process to assert those protections if necessary.
Okay. How does OCWR proactively engage with Congress to network itself?
Well, I think a lot of it is through the training, a lot of it is through our newsletters and other information. We do a brown bag quarterly, and that's from our Office of General Counsel. We work regularly with employment counsel throughout the legislative branch and attorneys who represent employees. So, I think that all of those are opportunities for us to engage with the covered community.
Great, great. Well, thank you. I know I have a little bit of time left, Madam Chair. I would like to ask the members of the Board of Directors, how often does the Board of Directors meet?
We try to meet about every 5 to 6 weeks if we can. Of course, we used to be meeting in person. Now we try to meet, now since COVID, we've been meeting virtually. We also meet by conference calls. There are a lot of times where things are not finalized within an in-person meeting, and we will schedule a conference call in between this 4 to 5 week period. But it seems like the 4 to 6 week period of time in between in-person meetings has worked out pretty well.
Oh, thank you, Ms. Wallace. Now, it's my understanding that the Board of Directors writes a report each Congress with policy recommendations. How often does OCWR receive feedback on those recommendations?
Theresa, do you want to answer that?
Yes, we do write a report that provides recommendations. It's not been a consistent feedback. We do meet with our oversight committees and often have conversations. So I can't give you a specific timeline, but we do have those interactions.
Well, great. Sorry, I yield back. My dogs are going crazy.
Okay. We have now Mr. Raskin, who is recognized for 5 minutes.
Thank you very much, Madam Chair, for calling this important hearing. In 1995, the Congress passed the CAA, which allows staff to form, join, or assist a labor organization for the purposes of collective bargaining. So this was like a mini Wagner Act, an NLRA for congressional staff. And it set up a 2-track process for the potential unionization of congressional staff. The first track went into effect when OCWR released regs for unionization of staff in certain legislative branch agencies like the Library of Congress and the Capitol Hill Police. And unions have indeed existed at these agencies for more than 2 decades. The second track allowed OCWR to promulgate regs allowing for unionization of staff in our personal and committee offices in both the House and in the Senate. But these regulations would not come into force until the House or the Senate passed a resolution adopting the proposed regulations that had been promulgated. These regs were indeed printed in the Congressional record, I think on September the 4th, 1996. But neither the House nor the Senate has ever moved by resolution to adopt these regulations. So the unionization rules have not gone into effect for the last 25 years, leaving members of the House and Senate staffs unable to unionize. So my first question is, are these regulations still live at this point and simply awaiting action by the House and or the Senate? Would it suffice for either house to pass a resolution to allow staff members in the respective chambers to organize? And I can, start with you, Ms. James.
Thank you. Yes, our board did propose regulations many, many years ago. I believe they were withdrawn. I think Barbara Kamens might want to speak to this.
Just to clarify, Representative Raskin, I do believe that you stated the historical course of events accurately in the sense that in 1996, our board adopted regulations that would govern the rights of collective bargaining and unionization with regard to members of Congress. So they were adopted pursuant to a section in our statute. I believe it's section 304 of our statute. They were then sent for publication in the Congressional Record. In order for them to go into effect and be issued, it would require action on the part of the House and the Senate through resolution. And I believe the position of our office is that those regulations are available for approval by Congress. Now, having said that, those regulations were issued by our board, I guess 25 years ago. It was before the current iteration of the board, and we have not addressed them in any of our 102B reports since that time. But you state the process, the historical process, accurately.
So do you think those regs would need to be updated or revised before the House or the Senate were to act on it? Ms. Kimmons?
It's our understanding in consulting with our general counsel that they are available for congressional approval.
Yeah, no,
We can
forgive me, but
yeah.
I don't mean in a legal sense or parliamentary
Okay.
sense. I mean substantively, are there changes that you think should be made before either house were to act?
Our board has not formally re-examined those regulations since their adoption 25 years ago, which was before any of us sat on the board, meaning the 5 current board members. We have not looked at them, we have not re-examined them, and we have not taken a position on them. So I would think that in order to respond to your question, it would require additional deliberation amongst all of the members of the board. I can't speak for the other members of the board.
Okay, thank you much for that. I'm just running out of time. One last question having to do with January 6th and the OSHA investigations. I know that you opened an OSHA inquiry into the lack of PPE that was provided or was not provided to Capitol Police. And there were other occupational safety and health concerns arising out of January 6th. I'm just wondering what's happened with the citation that you issued, citing 4 or 5 serious violations by the Capitol Police, and whether the Capitol Police have developed plans to better protect Capitol Police employees, whether these plans are underway or have been filed with you.
Congressman Raskin, let me just say that this is a matter that is currently in front of our general counsel. It is a matter that will ultimately or could very well come before us as a board. So it's very difficult and probably inappropriate for any of us on the board to comment on the citation that could come before us, and we need to stay back from it as best we can.
Gotcha. I think my time is up, Madam Chair. Thank you for your indulgence. I yield back.
Yes, and the gentleman from Georgia is now recognized.
Thank you, Madam Chair. Can you hear me?
Yes, we can.
All right. Thank you. Sometimes have problems with the setup remotely, but I appreciate the opportunity to participate in this hearing today. I'm going to start my questions with for Theresa James. Ms. James, sorry, my computer is acting up on me. As you know, Susan Grundmann, the current executive director of OCWR, has been nominated to the Federal Relations Authority. Ms. Grundmann has been with the OCWR for several years, leading the agency through the implementation of CAA Reform Act. My first question is, how important do you think the role of the executive director for OCWR is?
I think the role of executive director is very important. I think it's a position that obviously the management by an executive director is a key factor. And so, you know, that's the person that oversees the office, the hiring, the, you know, all aspects of the functioning of the Office of Congressional Workplace Rights.
Again, does OCWR have a plan to ensure a smooth transition to a new ED?
I think I can answer that. We have posted a job vacancy notice. Of course, we have no idea the timing for when Ms. Grunman will leave, but we have posted a job vacancy notice. We're beginning to get resumes in. Some of them, you know, you can put in a pile because they're not attorneys or something. They don't fit the qualifications that are required. As soon as we get those compiled, it's my responsibility as the chair to choose, along with the consideration with the rest of the board, the next executive director. So we'll go through the resumes as soon as we can and hopefully whittle them down, have interviews, and make a decision hopefully by the beginning of the year or soon into it. I will say, and I hope this is okay, Theresa, but Theresa, if there is a gap in there, Theresa James has agreed to be our acting executive director until a new executive director is chosen.
Do you foresee any particular issues during the transition period?
No, I don't. I think Ms. James is fully capable and the board is there to assist wherever we can. We don't have any particular issues that could be extremely controversial coming up other than the normal operations of the office. So I don't foresee that. And Ms. James has so much experience that it will be seamless, I think.
So you mentioned you can set aside some of the applications or resumes. What qualifications is the board going to look for when you're interviewing the candidates?
We've had a lot of discussions on this. We're looking for someone who has management experience because it's managing an office of 30 employees. It helps to have legislative experience because dealing with Congress is a whole nother world. And if somebody has some experience with that, it's very beneficial. A background in labor and employment is essential to understand our laws and to be able to quickly pick up on it. So those are the primary things that we're looking for.
In your process of selecting someone, do you have plans to consult with a committee as you're interviewing these candidates?
Are you talking about bringing particular individuals' names?
Well, just to
before you?
consult with the committee in any aspect as you're actually going through the selection process.
I would be more than happy as the chair to speak with our oversight committees in the House and in the Senate as to what you're looking for, because that's important. It's been wonderful that our office is having monthly meetings with CHA staff, and we appreciate that coordination with your staff, and you see things that we may not see. So I would be very open to meeting with the staff or with any of you to find out what you think is important in an executive director.
Well, I appreciate that. And also maybe the opportunity to meet your final candidates as going forward. So we appreciate that. And Madam Chair, I yield back.
Just yields back, and I think just noting that although we've not had monthly hearings on this, we have had bipartisan staff attention
Yes.
constantly. So we've been paying attention to this. I'd like to yield now to Mr. Butterfield for his 5 minutes.
Thank you, Madam Chair. Let me say good afternoon to all of my colleagues. It's good to see all of you today. I hope you're well this week. And let me also say thank you to the witnesses for your testimony. Your work is obviously very, very important. Let me start with one of the board members, whether it's Ms. Wallace or Ms. Kamens. And I prefer Ms. Kamens, I suppose. The board has recommended, Ms. Kamens, that claimants should be allowed to initiate mediation without any objection by an employing office. Do you track the number of cases or the number of complaints where an employee requested mediation and the office has actually denied the request? And if so, can you tell us the number of cases where this has been an issue? why do you believe it is important that claimants be permitted to initiate mediation without any interference from the employing office?
Representative, we
Butterfield?
believe that approximately 15 to 20% of the requests that have been made by claimants for mediation have been turned down by the employing office. We see that as a sufficiently material percentage that we are recommending a change to the procedure that is set forth in the Congressional Accountability Act. We have great faith in mediation. We have a lot of history under our belt where we have seen the very professional, skilled mediators that we retain through our office assist parties in finding a way to a voluntary resolution of their workplace disputes. Now, we understand that under the old system, mediation was mandatory. It was a jurisdictional prerequisite. We understand that mandatory mediation doesn't make sense because that does not always serve the interests of a claimant who might be, frankly, intimidated by the process. And I think there were also concerns that mandatory mediation simply delayed access to the exercise of statutory rights. But giving the claimant the opportunity to determine whether they want to attempt to explore a voluntary resolution makes a great deal of sense to our board.
Yes.
And
you
so
know,
we think that
it seems to me that there ought to be some inferences that can be drawn. Anytime an office, denies the request, there should be some inferences. Some years ago, the chair, Ms. Lawford, and I served on the Committee on Ethics. And, there were cases when there were accusations made against a sitting member of Congress. If that member refused to cooperate, our committee could draw some negative inferences. You may recall that, Madam Chair, we could draw negative inferences from their refusal to cooperate. And so, I would hope that 20% number would become 0%. Let me go to Ms. James. Ms. James, thank you for your contributions over the years. You've been there since for more than 20 years. Just thank you for all that you have done. Let me. What has been done? Let me go a different way. Do you believe that OCWR has enough IT support to carry out its mission? And do you have a strategic plan, an IT plan?
Yes, actually, we do. We have a strategic plan that does include IT. In fact, that's one of our goals. We have been working to enhance our IT infrastructure. So we have an IT security person and we have another IT person that just came on a few months ago. It is our goal to ensure that our system of confidential filing of claims stays confidential and the information with the office stays safe.
Let me use the last minute, if I can, Ms. James, in talking about educational materials and videos. In the development of these materials, do any of your staff undergo any specialized training or educational programs when you develop educational materials or videos?
Yes. Basically, all the trainers in the office are attorneys, so they understand the concepts that underlie the laws that we apply. They've also gone to training in through universities and other various programs to talk about how to have effective educational programs. So we
What
also
about consultants? What about consultants? Do you utilize consultants?
occasionally utilize consultants, but that would be just to sort of help our staff get through creating materials. But we ensure that our staff are fully prepared to do the work that they are required to do.
Thank you so much. Right on the button, Madam Chair. I yield back.
Thank you. Mr. Stile is recognized.
Thank you very much, Madam Chair. I would like to take the time to speak with Ms. James. In particular, I want to focus my time on the workplace rights training, and in particular, what feedback you've received from offices on the workplace rights training this year. As you're well aware, due to the COVID-19 pandemic, workplace rights training moved from in-person training to a virtual format. And I'm sure Ranking Member Davis understands, as a former district director, often we don't think what works in DC, sometimes it doesn't work the same way back in the districts. Many people were making long drives, spending possibly a full day just to obtain the training. we really turned that on its head during the period of COVID, moving it to a virtual process. Could you share with us some of the feedback you received from offices, in particular, whether or not they're wishing to keep that as a virtual training or a virtual option?
So our experience has been that the virtual training option works very well. In other words, you've got people who are able to interact with the trainers. The trainers can even do, certain exercises with their staff. There's a way to have them rate the training when it's done. The rating that we get back is pretty high. We do training on the Congressional Accountability Act as well as on implicit bias, bystander intervention. We're just now on ageism. So we continue to develop our courses, and we do find that it is effective as much online as it is in person. And in fact, I think as someone said earlier, it is even more accessible. So, we have really moved into this world where we're now all able to do Zoom. That a couple of years ago, I was in a panic when I had to have a Zoom call. Now it's become commonplace. And I think also with training, it's been very useful.
I think that's true. Let me jump down into the availability, because I think you bring up a really interesting point. Anecdotally, I got a lot of feedback where people were having trouble finding available spots. With training being completely virtual, I was somewhat curious why that was the case, that classes had limited numbers of people who could attend, and whether or not it'd be possible to allow more or an unlimited number of staff or interns to join a training. Have you heard that feedback? Can you provide any color to that?
We haven't had that feedback, but I think you might be talking about the House required training. And that is something that is done in-house and that we do not provide. So we do provide training on the Congressional Accountability Act, but the House mandates its own training. So
Understood. Okay, that's a helpful nugget. Maybe something that we as a committee could look into, and ways to continue to streamline those types of programs. I appreciate that. Looking at who's running the training programs, with CAO managing the contract, but Franklin Covey actually creating and running the training programs, it's come to the attention that OCWR is interested in being the entity that manages the contract and is the office charged with implementing the CAA Reform Act. In your opinion, does OCWR have the capacity to handle the contract for this training?
well, in terms of handling the contract or in terms of providing the training?
The training.
The training. We may need to look and reassess some of our resources at this point, because I think that my understanding is that the staff has to take the training within a certain period of time. And there are, approximately 15,000, 16,000 staff that need to take it annually. So I do think that we would need the resources to be able to do that. Our budget is, it's growing, but it's still relatively small.
So the outside provider has a better ability to flex their staff at a period of time when that training comes annually due in the House?
At this point, yes, but I think that we have the expertise to be able to handle the training and to be able to provide the answers that may be more useful for staff.
Okay. With the minute I have remaining, I'd like to go back. Mr. Butterfield touched on this, but I want to just give you a little more time to elaborate, in particular as it relates to improvements to the IT systems at OCWR. Is IT in an increased digital presence a real focus for OCWR? And how do you analyze IT more broadly?
I may have to defer on that question and get back to you. And I say this only because I am not an IT expert. We do have two on staff who work very closely, who manage our contracts, who work with different providers, work with the Library of Congress. We are on their system. I'm happy to answer this question with you offline or provide you with any information that you need.
That'd be great. I think it's just an area we should keep an eye on. I appreciate you spending the time with your team to come back with a little bit of color for the committee. Madam Chairwoman, cognizant of the time, I yield back.
Yields back. Ms. Scanlon is recognized.
Thank you, Madam Chair, and thank you for calling this hearing. It's of particular interest. I came to Congress 3 years ago this week on a special election to fill one of the several seats that were vacated that year because of Me Too issues. And one of the first laws that was enacted within a month of my arrival, not that my arrival had anything to do with it, was the Congressional Accountability Act reforms. And so it is a topic of particular interest. And as a matter of personal privilege, I guess I'm going to pick on Ms. Kamens because we attended the same law school together. I believe at the time she was head of the women's law group. My husband was part of the men's auxiliary. So it's good to see her again. I was struck by something in your testimony about the fact that in the wake of the Me Too movement, it's apparent that education merely addressing the letter of the law is insufficient to transform the climate in the legislative community. And that there are a lot of factors that lead into that. We still only have 27% of Congress is female. There's increasing generational divides. And I just was wondering if you could elaborate on that, on what more we can do to educate people, to bring people along, particularly when we have some fairly stark gender divides and increasingly generational divides in how younger people look at some of these issues of harassment that their elders don't often perceive.
Thank you, Representative Scanlon. It's nice to see you. So as I said during my opening testimony, we have taken, I think, an ambitious and innovative approach to our training program. We learned in the wake of the Me Too movement on Capitol Hill, the teaching to the letter of the law just was not sufficient to transform culture. So we offer a wide array of programs, which I'm sure Ms. James can address in more detail, including, for example, we offer a bystander intervention module, which we think is very effective. We have found, certainly, and studies have been done by professionals, that if individuals recognize behavior, which, if it continues, may result in unlawful conduct, it's very effective to give individuals strategies for how to intervene and nip that conduct in the bud. So that's a perfect example of a training module which we offer, which goes beyond the mandatory anti-harassment and anti-discrimination training that is required by statute and resolution, but I think is very, very valuable. And we would encourage employing offices, both member offices and employing offices across the congressional workplace, to avail themselves of this training. It's available, on the website through modules. We can tailor, make an in-person training program that we can deliver through this, new technology, and deliver it online. And it's just a matter of changing underlying behaviors and teaching best practices. I think that across the congressional workforce, all employing offices understand that there's a need to professionalize the congressional workforce, competing to recruit and retain the most talented staff that we can. And I think that this kind of ambitious education program, which we have, and which we are ready, willing, and able to deliver at the request of any employing office, should be utilized as much as possible. Again, beyond the letter of the law.
And I think that relates to, I sat on the select committee to modernize Congress last term, and that this whole line of discussion relates to the idea that we have these best practices available now through your office, through House Admin, through the new diversity office. And we need to find more ways to encourage offices to take advantage of them and stop having so many chiefs without proper guidance. So thank you, and I yield back.
Thank you. The gentlelady from New Mexico is recognized.
Thank you so much, Chairman Lofgren. And for witnesses, this is such an important question because it impacts all of those who work with us. And of course, Congress can't function without all the amazing employees who work here. From those working in own offices, the interns, there was great conversation today about the unpaid staff, and of course, the Capitol Police. Mr. James, I want to make sure that the service you described actually reach employees and are tailored to them, whether they work in the capital or across the country in our diverse districts. Can you describe a bit the kind of training that your staff, including the confidential advisors and mediators, receive to ensure that services are provided? And also, I have an incredibly diverse district, and all our members have diverse districts. How are they done in a culturally relevant manner?
Well, thank you. It's a very complex question, and there are lots of things come to mind. I don't think that our trainers actually are multilingual, but that's something to consider. They are able to provide training via Zoom, as I mentioned before. We have a sign up on our website. There's, learning management system that employees can go to. There are videos on our website. They can contact our office and request training. We provide the training via Zoom on several issues, including the Congressional Accountability Act. As far as the confidential advisor, she provides information on a one-on-one basis. So in other words, she's not necessarily involved in training. She's involved in informing staff who might call the office and say, I'm not sure if this is an issue, concerning my rights under the Family and Medical Leave Act, or the Fair Labor Standards Act, but she will deal one-on-one with people. Our trainers deal with the education program, and some of our attorneys on the Office of General Counsel also provide a brown bag. And that's giving information on the various provisions of the CAA and the legal status of some of those decisions and other cases that are affecting them.
Thank you. And I know that you touched on this earlier in the conversation, but how are we making sure that, especially in our district office, people are understanding what that these services are available?
Right. So we do reach out to, we do send out quarterly newsletters, and we have information available on our website. So all of that goes to everybody. All new staff get hard copy brochures from us. And so we do regularly reach out to staff located in the DC area as well as in district offices on a regular basis so that they have this information.
Thank you. I now want to go to the 2019 report, Mr. Chair Wallace. Back in 2019, the GAO wrote that the OCWR lacks results-oriented performance goals, related measures, and reports assessing progress. So it's been about 2 years since that report. Can you describe what performance measures you've been put in place, and can you make sure that the committee gets information about that?
The board, in conjunction with the staff, spent a considerable amount of time developing a new strategic plan for our office. And the GAO report had mentioned a number of things that they felt should be in the strategic plan. And we worked very hard on it, coming up with 5 different goals, which I can tell you what the goals are if you're interested. But for each one, we set various initiatives and action items so that we could judge from those what our actions have been, and have we been meeting the goals? Are we meeting them? What are the timelines? So I think we've become much more organized in that regard. Strategic goals are becoming much more important for offices to do, especially within the government. We are doing that also within our IT realm. And as a matter of fact, one of the goals in the strategic plan is to work IT into more and more of the things that we're doing to update how we interact with people, that type of thing. So we've taken the GAO report to heart. We're working with them, advising them on the steps that we've taken. But I think the strategic goal, which is available on our website, is probably the biggest thing that we've done to follow through on the kinds of things they asked us to do.
Thank you, and my time has expired. I yield back. Thank you, Madam Chair.
Thanks very much. I see Mr. Aguilar is here and he is recognized.
Thank you, Madam Chair. I appreciate it. Appreciate the panel, and sorry for my tardiness. Ms. Kamens, in your testimony, I saw you mentioned how OCWR is ensuring that offices are compliant with workplace rights dictated in CAA, obviously. However, this isn't always enough to create transformative change within the workplace. Does OCWR's mediators and advisors, do they receive implicit training bias, or they, how equipped do you feel they are in dealing with scenarios or cases that resolve around workplace issues of race and culture?
Thank you for the question. I may need to defer on some of these details to our Deputy Executive Director, but I can attest to the professionalism of our staff of mediators who assist the parties in exploring a voluntary resolution of their workplace disputes. They are expert on the wide array of workplace and employment issues that are implicated by the Congressional Accountability Act. So we think that they are well positioned to assist the parties in determining whether there is a way forward to voluntary resolution. I don't know whether I can turn to our Deputy Executive Director, who might be able to talk more specifically about the training that they receive.
Sure.
Certainly, thank you. Yes, we do have professional mediators and hearing officers, and we also do accept feedback from parties. If they have an experience that makes them uncomfortable, we will take that into account. They are all attorneys who are experienced in the areas of labor and employment law. We do provide them with updates annually on the Congressional Accountability Act, any changes with it. We have a summit annually bringing all of our mediators and hearing officers together. We have not had issues come up that I'm aware of that concerns discrimination as a mediator or a hearing officer. But if something like that were to come up, we would take it very, very seriously.
Any issues about implicit bias training, or just broadly, we saw after January 6th that some congressional offices had experienced a different degree of issues. And so just kind of in the broader category within discrimination of racism and inappropriate comments being leveled, do you feel that you are adequately, prepared, and that the attorneys on staff are adequately prepared for that type of, anti-reprisal, training and everything that goes along with that?
I do think that we're fully prepared for that. In fact, we have our own implicit bias training that we provide, and we are also in the process and will shortly have an implicit bias video up on our website. So I think that for staff of the OCWR, it's required. So it is something, it's an area that we are very, very aware of. And I think if we had any sense that anybody who was working for our office as a contractor was in any way, behaving inappropriately, it would be upon us to remove that person, because we certainly wouldn't want that behavior to, taint anything that we do.
I appreciate it. Ms. Kamens, under the current mediation process, the employee and the employer must consent to mediation. In your testimony, you said that this effectively gives the employing offices a veto over claimants who wish to attempt to settle their claims with the assistance of OCWR. Can you describe or explain in more detail? I don't have a ton of time remaining, so I apologize. The recourse that an employee has once the current or former employer denies participating in mediation?
Under the current process, mediation would not be available to that claimant, and it would be incumbent upon them to proceed through the steps in the Reform Act with regard to our ADR process. What we are suggesting again is that we broaden that right so that any claimant who seeks access to mediation gains access to mediation, and the employing office will be brought in. And of course, under the procedures, then the time limits under the ADR process would be stayed during the course of the mediation. So we have so much confidence in our mediators. We see it as such an effective tool. We see mediation as the means of potentially gaining a timely resolution of a workplace dispute, and that is why we are requesting that the Reform Act procedures be reconsidered to allow mediation under all circumstances where the claimant seeks access to the process.
Thank you so much. My time's expired. Thank you, Madam Chair.
Thank you very much. Now I will recognize myself for just a couple of follow-up questions. We've addressed the issue of cybersecurity somewhat, but in a GAO report last year, there was concern about cybersecurity, and they point out that OCWR had not developed an organization-wide cybersecurity risk management strategy. They commend you for having a strategic plan, a goal to do that, but pointed out it had not, there hadn't been an effective approach for managing organization-wide cybersecurity risks. So I'm interested in what progress has been made in establishing that approach to cybersecurity. And Ms. James, I don't know if you can answer it or whether you want to get back to us on that, but obviously we advertise a secure portal. It's very sensitive information that employees may be lodging, and we want to make sure that it's secure.
Yes, thank you. And I will have to get back to you with more information on that. I appreciate it.
Okay, well, let's figure out a time in the next several weeks where the majority and minority can be briefed on the cybersecurity steps that you all are taking so that we're all on the same page. I was interested in the ranking member's comments, and I agree with him that the remote training works so much better for district offices. And, originally, I mean, a few years ago, pre-pandemic, when we were thinking online training, we were thinking sort of, you have a website and really there's no interactive component to it. That's completely changed. I mean, the pandemic has been a terrible thing for the people of our country and the world, but the one good thing that has come out of it is the movement to have really virtual meetings that are like meetings instead of just a passive delivery of content. I'm wondering post-pandemic whether you would intend to continue that type of outreach and training, not just for district offices, but also for people in Washington.
I'd be happy to answer that question. And yes, absolutely. If it is the most effective way to reach more staff throughout the legislative branch, we're happy to do it remotely. Initially, I think everyone thought in person was going to be the most effective way. And here we are 2 years later realizing that, it is as effective remotely as it is in person.
Well, and it's interesting because I remember when we put this together, and I want to give due credit to our colleague, Jackie Spear, who worked so hard putting the pieces together, and we wanted to make sure there was engagement, but clearly you can have that engagement with a WebEx or a Zoom. It's not like you turn on your web page and then maybe you go, cook dinner while it's running. It's a very different experience. And also the capacity to have a wider audience and one trainer and still be effective is present. So I would encourage the office to continue to do that. And I'm wondering along those lines, I mean, with a virtual environment, we have the capacity to do even more. How do you select topics, educational topics for outreach and trainings? And what are the most popular ones or the ones most in demand at this point?
Thank you for that question, because what we have often is after we do the training, we will ask people, to rate the training and to give us any suggestions about what topics they'd like to see covered. So, that's something that we do now as we have our after training forms filled out. But we also look to issues like implicit bias, which we're seeing more and more of. And we're doing that in a way that is really just helping to raise awareness among staff of their interactions with one another. You know, we all have our own ways of doing things, and it's really a matter of just being mindful as to how you interact with your colleagues. So we're looking at focusing on implicit bias. There's also bystander intervention, which I think was mentioned earlier, and that's a training where if you see something, say something. So a way of sort of diverting any inappropriate behavior in the workplace. We do training again on racial equity, civility, and inclusion, and we are moving into ageism and sexism too as we continue to develop our category or our list of courses. But predominantly it is training on the Congressional Accountability Act, which is mandated throughout the legislative branch.
Well, I thank you very much for your answers to my questions and the questions of all of the members. We'll look forward to an update in the near future on our cybersecurity situation. And at this point, I think all members have had a chance to ask their questions. So I would note that we may have additional questions for you. If so, we will send them to you, and we would ask that you respond to them in writing as soon as you are able. And with that, unless there are further matters to come before us, this hearing will be held open for the responses, but without objection, the committee will now be adjourned. Thank you so much.